let's just get on to it. What is summary judgment? Before we started, summary judgment is a kind of interim application. So that one thing you need to know is one of the kind of interim application. So we're going to deal that way. So summary judgment is a procedure under CPR Part 24 which allows the court to decide the whole claim, part of the claim, or a particular issue without going into a full trial. So let's quickly go back and we're gonna break it down one by one. Summary judgment is a procedure. CPR 24 deals with this, which allows the court to decide either a full part of the claim, partial claim, or a particular issue without going into a trial. Its purpose is to prevent the parties and the court from spending more time, money for the preparing a trial where one side's case has no real prospect of success. It supports the overriding objective, CPR 1.1, because it enables the weak claims or defenses to be dealt swiftly and proportionately. So bottom line is, we're going to come to an example on that if you submit a claim and a defense comes in response and you think there is no real defense, or the person already admits, say, they don't have money, that means the claim is already admitted but they're not defending the claim. So instead of going to the trial, spending more money on it, you can just simply go for a summary judgment. So in that case, the judge can look on this both whole of the case from the both parties. They can decide, so it's going to save your time, money, and the courts, especially most of the court times. So summary judgment may be granted in favor of either a claimant or a defendant. For example, a claimant may apply where the defendant has filed a defense but the defense is plainly unsupported. A defendant may apply where the claimant's evidence cannot establish an essential part of the claim. So summary judgment can come from any side, either from a claimant or from a defendant. So where one party sees the other party case is so weak, does not have any essential part, or cannot establish the legality or facts, then they can apply for the summary judgment. If the summary judgment is granted only on one issue rather than the whole part of the claim, then that issue is finally determined and will not need to be considered at the trial. So the remaining issues may continue to trial. As we said in the very start, that summary judgment does not have to be on the whole matter. It can be on the whole matter, partially, or only on the specific one or many issues. And the remaining, if still disputed, they can go on a trial. Let's just quickly go for a real life example. A lender brings a claim for repayments for a written loan of £40,000. The defendant admits receiving the money and signing the contract, but argues that repayment would cause financial hardship. Now look at the scenario again. So a lender bringing a claim for £40,000 loan against the defendant. Defendant says, yes, I have received the loan, I have signed the contract. He's not denying. So that is admitted fact. He admitting that he signed the contract. He admitting that he has taken the loan. Only the part he is saying it that repayments would cause financial hardship. That has nothing to do with the case. The court can easily file a judgment on there, because repayments, installments, how you want to pay for it, or you cannot pay for it, that's not the court's problem. The court problem is the money, the issue is resolved. So final hardship is not normally a defense to liability under the loan agreement. The claimant may therefore apply for a summary judgment, so they don't have to wait for going for a full trial because everything is established, because the defendant appears to have no real prospect of successfully defending the claim. Now let's quickly go for the test for summary judgment. So under the CPR Part 24.3, the court may grant a summary judgment against a claimant or a defendant on a whole or a particular issue where two conditions are satisfied. First, the relevant party must have no real prospect of succeeding on the claim, defense, or issue. Second, there must be no other compelling reason why the case or issue should be dealt with at full trial. So let's quickly go through the both conditions again. Number one, the relevant party, the one who's applying for the against, they have no real prospect of succeeding on the claim, defense, or the issue. Second, there must be no other compelling reason why the case or issue should be dealt with at full trial. So one, they have no real prospect of succeeding in the matter, and the second, there is no other compelling reason why the case or issue should be dealt at full trial. It is important to use the word no real prospect rather than saying merely the case is weak. That's two different things. A real prospect means a realistic rather than fanciful chance of success. So that's the right terminology. The second part of the test recognizes that a trial may still be necessary even where one party's case appears weak. For example, a trial may be required because important facts are disputed, witnesses must be cross examined, expert evidence is needed, or further evidence is likely to become available. So, where the case is weak, that's different. Where the person have no real prospect of success, that's two completely different things. So, you have to be very careful on that. Is commonly tested in SQE2. So, correction to the slide reference. Old material commonly refers to the test CPR 24.2. Following the restructuring of Part 24, the current grounds are found in CPR Part 24.3. CPR 24.2 now deals the type of proceedings in which the summary judgment is available. Now, let's quickly look on evidence required for the summary judgment. An application for the summary judgment must be supported by sufficient material to demonstrate that the legal test is met. That is very important. So whenever you're applying for a summary judgment, the supported sufficient material must demonstrate to support your application that the legal test is met. Application notice must state that the summary judgment is sought. So obviously in the application N244, you must say that what you are looking for. So you're looking for a summary judgment. It must identify concisely any point of the law or document relied upon and set out or attach the applicant's written evidence. So number one, you need to N244, the application form. What are you looking for? Summary judgment, for example. Why you looking for? That means you need to give the reasoning why you think the other person does not have a real prospect of success, and then the relevant evidences and the relevant fee of the court. So the application notice must state that the summary judgment is sought. It must identify concisely any point of law or document relied upon and set out or attach the applicant's written notice. It must also state the applicant believes that the respondent has no real prospect of succeeding on the relevant claim, defense, or issue. It depends which one you are going for. Either you're going for a full case, then you state the full case. If you're going for a partial, then partial. If you're going for a specific issue, that means summary judgment also help narrowing the issues down before you go to the trial. And that the applicant knows of no reason why the matter should wait for the trial. The respondent must be told that they have the right to rely on evidence opposing the application. So in this case, you cannot do without notice summary judgment. So you must be serving this on the defendant as well. Will come up in later on this slide. Evidence will usually be given through the witness statement supported by the relevant documentations. However, the court may also consider the statement of case, contracts, correspondence, admissions, and other documents already filed. So remember, when court sets the hearing for summary judgment, it is never a full trial. It is a hearing but not a full trial. So let's quickly go through an example. A supplier claims payment of goods delivered to a retailer. The supplier relies on signed contract, delivery notes, invoices, emails admitting the receipt, and email promising the payment. The retailer's defense simply denies owning the money, but provides no explanations or evidences. The documentary evidence may support the claimant's application for the summary judgment. So it's pretty straightforward. The supplier has 5 things: signed contract, delivery notes, invoices, emails admitting the receipt from the other side, and email promising for the payment. So in the retailer, as I said, when you file the defense, if there are 3 things you can do in a defense: either you can admit, you can deny, or you can put the other claimant to the strict proof. So when you deny something, simply saying the allegation is denied is not good enough. You have to give reasoning next to it or give your own version next to it. So simply denial is not good enough. And the fourth most important thing, if you miss any point in the against a particular claim in your defense, that missing effect may sometimes be taken as admittance. So you have to be very careful. That's why whenever you prepare a defense, you have to mention every single point of the particular of claim. Okay, summary judgment and strikeout. there is a considerable overlap between summary judgment under Part 24 and strikeout under CPR 3.4. In suitable cases, a party may apply for both orders in alternative cases. So striking out the case is different, summary judgment is different. Summary judgment is dealt under CPR 24 and striking out judgment is dealt under CPR 3.4. However, two procedures have different focuses. Let's talk about the striking out. Strikeout is mainly concerned with advocacy. Sorry, my bad. Strikeout is mainly concerned with the adequacy of statements of case and procedural misuse. The court may strike out all or part of the statement of case where there are three things. It discloses no reasonable grounds for bringing or defending a claim. So when you have no merits of the case, are you just bluffing? It is an abuse of the court's process, are likely to obstruct the just disposal of the proceedings, or a party has failed to comply with the rule, practice, directions, or court order. So when it comes to three things, when the court thinks disclose no reasonable grounds for bringing or defending the claim, the court can strike out on the application of the other side. Sometimes their own initiative as well. Or it is abuse of the court's process or is likely to obstruct the just disposal of the proceedings, or the party has failed to comply with the rule, practice, direction, or court order. The court is often asking, even if the facts pleaded are assumed to be true, does the statement of case disclose a legally recognizable claim or defense? That is very important. So when somebody is asking for striking out the claim, they ask normally that even if the facts pleaded are assumed to be true, does the statement of the case disclose a legally recognizable claim or defense? For example, a claimant sues a neighbor merely for being rude without alleging defamations, harassment, breach of contract, or any other recognized cause of action. The particular claim may be struck out because they disclose no reasonable legal grounds for bringing the claim. So just being rude, no defamation, no harassment, no breach of contract, or any other recognizable cause of action. So they just be bringing a claim because of rude, so that's likely to be struck out. Now, summary judgment focuses on more directly on the realistic merits of the claim or defense. The court considers whether the party has any real prospects of succeeding and whether there is no other compelling reasons for a trial. The court may examine evidences as well as the statements of the case. The court is asking, does this party have a realistic prospect of proving its claim or defense at trial? For example, let's take an example of summary judgment. A claimant produces a signed agreement, invoices, delivery receipts, and an email from the defendant admitting the debt. The defendant pleads that no money is owed but has no evidence supporting to that opposition. The defense may be legally recognizable on its face, prima facie, so strikeout may not be appropriate because they're still admitting the claim. So striking out, no, because the other party have a legality of the claim and facts. So the defense may be legally recognized on its face, so strikeout may not be appropriate. However, summary judgment may be granted because the defendant has no real prospect of proving the defense. Now, the practical distinction, a useful in SQE 2 distinction, is strikeout attacks the pleading or procedural conduct. Summary judgment attacks the realistic merits of the case. That is very important. So strikeout attacks the pleading or procedural conducts, and summary judgment attacks the realistic merits of the case. Not weak, merits of the case when the other person have no real prospect of the matter and there is no other compelling reason why the matter should be dealt at trial. That's for the summary judgment. Where both grounds appear relevant, the applicant may combine CPR 3.4 strike out the application with Part 24 summary judgment. So where you think the both things are coming up, you can use both as well. Just a quick one, last one, the summary judgment and default judgment now. That's also two different things. Summary judgment must be distinguished from default judgment under CPR Part 12. We already spoke on the default judgment. Default judgment is procedural. It may arise where the defendant has failed to file an acknowledgment of service or defense within the required permitted time under CPR. That's procedural. Again, summary judgment is different whether other person no have no real prospects of claim, and striking out when the other person's case is meritless. So that's three things. Please do not get confused in that: default judgment, summary judgment, and striking out. Default judgment is dealt under CPR Part 12. Default judgment is procedural. It may arise where the defendant has failed to file an acknowledgment of service or defense within the required permitted time. The claimant may obtain a judgment because the defendant has failed to respond properly to the proceedings. The court does not normally conduct a detailed assessment or whether the claimant's case is strong or weak, because the claimant will win anyway without even going to the trial. For the default judgment, court does not look at the merits of the case. If the defendant has not filed the acknowledgement of service or defense, then on the 15th day, for example, the claimant can apply for default judgment. So that will be a win-win after that without even going to the trial. A defendant, for example, a defendant is properly served with a money claim but files neither an acknowledgement of service nor a defense within the required period time. The claimant may request for a default judgment provided the remaining conditions in Part 12 are satisfied. So summary judgment is based on the merits. The opposing party may respond it fully, but its claim or defense has no realistic prospect of success. In default judgment, the other party, mean defense, have not even filed the acknowledgement of service or defense on time. Summary judgment, the other party have responded and they can respond when you apply for a summary judgment, but they don't have any realistic prospect of success. Examples again, once quickly go through the examples again of summary judgment. The defendant files a defense on time. However, the defense is contradicted by the defendant's own signed agreement and written admissions. The claimant cannot seek default judgment because they have responded on time. So the court have no power once person files the defense or acknowledgement of service. Then court has no power of giving the default judgment under CPR Part 12. But if the defense is weak, contradicted, or vague, or they simply says denied with no reasoning, no real prospect of success, then the other person may apply for a summary judgment or strike out. They can mix both as well, CPR 3.4, CPR 24. So they can apply for both as well. So the claimant cannot seek default judgment because the defense has been filed. The claimant may instead apply for summary judgment or striking out, or both. Easy distinction. Default judgment, the defendant has failed to respond on time. Summary judgment, the opposing case has no real prospect of success, whether claimant or defendant. Strikeout, the pleading is defective, abuse of process, abuse of procedure, or abuse of the court process. Now, I think we're going to conclude the video here, and in the next video we will be talking about who can apply for the summary judgment, and the next we're going to when should the application be made, effect on the